legislative history of RUTA that it was intended for a discriminating purpose? So shouldn't we recognize that legislative history?
Well, that was...
Because you told me it's just critical.
Yes, Your Honor. However, for the 21st Amendment, there were several cases that have discussed it as looking at promoting temperance, ensuring orderly market conditions, and raising revenue. At the case at hand, there was...
I wish that when I was at law school, my law school had offered a moot court program like we have here.
It's an opportunity to not only be impressed at your peers and the work that they're able to do, but to kind of wow yourself.
You can get a very good idea of what kind of lawyer you think you'll be and what kind of lawyer you want to be.
Between the writing skills and the speaking skills, those two things are really invaluable, not only as a student, but when you enter the workforce.
If you are able to convince somebody of what you want to convince them of, that transfers to any kind of thing that a lawyer does. We use their scores from those briefs and oral arguments to invite 40 second-year students to participate in the Hale Moot Court Honors Competition.
The tryouts for the first years are in April, and the final competition for the existing participants is in March. So I sat there and I watched, and I couldn't believe how polished the participants were, how well they knew their arguments, how great they sounded, and the really good feedback that they got from judges. And the judges are federal appellate court judges, very, very impressive people, just giving them glowing remarks. So at that point I thought, okay, this is something I have to do. This is something I really want to do. So I tried out as a first year and then participated as a second year, and then a year later found myself literally in their shoes doing the same competition in front of, these big, powerful judges.
Third years get to be on the executive moot court board. If they participated and done well in the competition, then they get invited to run the program as third years. During the summer, the third year board and I work to create the competition case. Every year, many of our guest judges tell me that we have the best moot court competition, and one of the reasons is that we work extremely hard to make our competition case realistic. I make sure that the moot court competition case is both high quality in the fact scenario, the issues that are raised, and that it presents a realistic scenario, something that a practicing attorney might actually face. Beginning of the fall semester, the second years who've been selected based on their performance, the first thing they do is they write an appellate brief based on that competition case. Those executive board members that work over the summer with me to create this wonderful competition case then also get assigned to essentially mentor some of the second year participants as they're competing. By October, November of the fall semester, they begin in their oral rounds, which is the oral advocacy component.
I think most of us in law school are competitive by nature.
All rise.
Yes, there are avenues to compete with your students as far as grades and being in class, but that's not quite the same as going through a competition, putting some pressure on yourself to succeed, and then really succeeding at it. And I think it really fulfills kind of our competitive desire.
Good evening, Your Honors. May it please the Court, my name is Drew Anderson, co-counsel for the respondent, Brandon Riley, and Bruin Winery. Your Honors, this evening this Court should affirm the holding of the 12th Circuit and find that Section 1145 is an unconstitutional. The first taste I got of it, I was kind of hooked. From our very first practice round in my writing course, my mind sort of slowly started to change.
I think I really enjoyed the excitement of the competition, the adrenaline rush that you get when you're standing in front of the judges. You're about to start, they're asking you these really difficult questions, and the feeling that you get when you're ready to respond and when you give a good answer.
USC Law doesn't have any sports teams, but I think this is as close as you can get to something like that.
If you want to be a litigator, it's a great program, because you're going to get experience on how to stand up and answer questions. But in addition, even if you want to be a transactional lawyer, you need to have oral advocacy skills as an attorney. You don't want to be locked in a library. Nobody does. You're going to be meeting with clients. You may have a stubborn client that wants to do something that the law doesn't really allow. You have to convince them that they should do the right thing, that here's what they're legally allowed to do, here's what in your training experience is a smart thing for them to do.
It's a tournament, basically. There's 40 people to start off, and one's going to survive, and there's just a different element to that kind of competition as opposed to just trying to do well on a final.
The judges are always the first to say that the advocates in the Hale program are better than the practitioners that they see arguing in front of their benches in real life. So that's a very common thing and something we're very proud of.
You know, getting feedback from other judges who are saying, I can't believe how well you've done this year. This is a great program. Everything went smoothly. Your participants were so prepared. And those kinds of things really make you feel good as a board member.
I have had in my first year class, because I also teach the first year legal writing and advocacy classes, students who said to me, I'm not good on my feet. I could never do moot court. And then they do surprisingly well. Because to really be an effective advocate, you actually have to understand the issues. And sometimes those people really do, they're thinkers. And they don't really have the confidence to begin with, but then as they start going through these various rounds and the practice rounds, and they're getting input back from the third years, they start to realize that they're good at this.
Moot court is always going to be a great opportunity. It's an especially great opportunity here because it is also an honors program, which helps you, honestly, in employment tremendously.
It's unique that it gives you both advanced written advocacy skills and advanced oral advocacy skills. You're going to start developing those, the written advocacy, in your first year. And you can take other classes that will give you oral advocacy, like trial advocacy, but there's no other class that combines both in the same way.
I mean, you get to actually kind of engage in the life of a lawyer with others who are doing the same thing. And there's, we have our happy hours, and we have our get-togethers, our dinners. There's certainly a great social aspect to it, which was certainly another positive aspect of it.
The Hale Moot Court program is the best thing that I did in law school. It's easily the most rewarding thing to go through.
Getting to know my classmates on that personal of a level has been really rewarding for me, and it's definitely characterized how I see myself as a student.
More than anything, you can expect out of the Hale program to be challenged, but to have a ton of fun doing it.